Okay, so we can start, I think. Welcome. Hi, everybody. I'm Caterina Demetsu. I'm a Policy Counsel for Global Privacy at the Future of Privacy Forum, and I'm a PhD candidate at Radboud University in the Netherlands. Welcome to our panel, which I will moderate. The title is Research Data, AI and Data Protection Law, What Research Exceptions Mean for the Development and Use of AI Technologies. Now, this panel will deal with one example out of many where data protection law and AI interact, and this is research. So we have personal data that can be processed for the purpose of performing research in various domains, for example, healthcare, but also in the context of AI. And research in AI is very important. And why is that? Imagine an example of having to train or develop algorithms, improve them. You need high-quality data sets that might include personal data. So general data protection law comes into play. Data protection laws often introduce a tailored regime which has to do with research. It's a special regime for research, often called research exception. And this panel will explore how data protection laws of different jurisdictions, mainly Latam and EU, deal with this issue, processing of personal data in the context of research for AI. So I have 4 panelists here and 1 remotely. They will shed light on the discussion, and we can start immediately. So first, I would like to introduce Pablo Palazzi. Pablo Palazzi is partner at Allende & Brea, director of the Center of Law and Society, and law professor at the University of San Andres in Argentina. He has authored several books on data protection. So, welcome, and the floor is yours.
Nelson, ¿nos escuchas? Desactivar mudo. Ahí. Ahí está. Ahí sale. Desactivar mudo. ¿Mudo? Lo estamos arreglando. ¿Nos escuchás, Nelson?
Ahora, te escucho, Pablo, te escucho, ahora sí.
Perfecto. Okay.
Gracias.
Sorry for the interruption, but Nelson is speaking after me, and if not. Thank you for the invitation to CPDP Latam. I'm Pablo. Caterina already introduced me. And I'm going to speak about Argentina and about the research exception in Argentina. Of course, I have bad news. Argentine law, data protection law, is 22 years old. So the advantage was that the first law in Latin America. The disadvantage is that because if it's old, it doesn't contain any research exception for anything. So basically, it's what I call first generation laws in Latin America, which started copying the model from the Spanish Data Protection Act, which are very binary, based on consent, no consent, no other legal basis. So basically, if you ask me something about Argentine law, I will answer you, can be done unless you have consent. No, we have other principles also that I will talk about. But I would like to frame this very brief research position in three issues. First, data protection. Second, copyright or IP law. And third, some issues related to policy, policy of this matter. With respect to second issue, which is intellectual property, as you know, compilation of information that are protected under copyright law, under sui generis law, which is a kind of specific law different than copyright that protect suite of raw and the effort on compiling data, and also trade secret. So what I'm going to say here only about intellectual property is that we cannot address the data protection issue without addressing also the intellectual property issue, which may also be an obstacle to using machine learning and using data for machine learning. Sorry, one more thing. I'm assuming that everybody knows that machine learning and artificial intelligence requires big data and access to a lot of data to train AIs, etc. And that's what we're discussing here. Sorry, I just jumped because I thought everybody know it. And so that's IP. Going to data protection, as I told you, In Argentina, we don't have a research exceptions than the one we have in EU law that you will find and that Lee will explain us very, very well. And also we have something called purpose limitation principle, which basically says that personal data which was collected from one purpose cannot be used for a different purpose or for an incompatible purpose, no? And this means that basically you will need consent to use data for other purpose unless you have requested very broadly the consent from the data subject. In addition, the consent concept was evolving during all these 22 years, and it's becoming more and more harder to obtain consent. Consent used to be something very binary, yes or no, and now it's evolving more for something more granular, and this is interpretation from the DPA in recent cases, which means that you need to request consent for one or more purposes, but purposes has to be stated in the consent and cannot be widely adopted. For example, a consent saying I consent the use of my personal data for any use whatsoever that the company knows or the company may use in the future may be null and void because such a blank check is not accepted under the DPA interpretation that currently does. So, and the purpose limitation principle is linked to consent because to be informed, consent has to be explained what you're going to use it for. And I'm going to comment a case in Argentina. It's called the Citibank case. The Citibank tell the customer that they wanted to use the information they have about them for marketing purposes. The privacy policy did not accept marketing purposes. And Citibank sent a letter to all the clients saying, if you don't say anything in 15 days, I assume that you consented and I will use the data. Of course, that's against express consent as required in the Data Protection Act. And several people bring lawsuits and claims in the DPA, and the final outcome was that this process from the Citibank was considered against the law because you cannot obtain consent just by silence. But also, when the Citibank appealed the fine, the Court of Appeal said, in addition to this, to not obtaining consent correctly, you are affecting the purpose limitation principle because the information that you have from your clients is to render banking services, not to do marketing. You didn't seek consent for marketing. People were not informed of the purpose of the collection was marketing, and now you want to change it. You cannot change it unilaterally. That was the conclusion under Argentine law, and that's the only precedent we have about the purpose limitation principle. And nobody has defined what is an incompatible purpose yet. If you go to the 10 books written about the law of Argentina, including mine, about what means incompatible with the purpose of the collection, everybody says that an incompatible purpose is a purpose which is not compatible with the collection, but nobody explains what happens. So, and we don't have cases from the DPA, so we are here kind of blind on this matter. So in Argentina, it will be very difficult to create for nothing a research exception. It's a problem, because I think that data protection law has to be combined with innovation and trying to find good patterns. And a third issue I'd like to comment was the issue about policy. And if we think about our research exception, we put it in the law in Latin America, and we say, okay, now we have very brilliant and modern laws because our laws contain a research exception. We can do AI programs, machine learning, etc. We've got this data. That's beautiful. But if you grant an exception, a general exception in the law, that exception is available to everyone, meaning everyone. So we need to ask ourselves, do we like to open our databases to anyone, or we like to put some requirements? And I'm taking this because you see that some trends people start speaking about data sovereignty, limitation on transfers. There's a lot of geopolitical issues with accessing data. And to put an example, there's something in the US called the National Security Commission on Artificial Intelligence, which is a very important report issued last year. It's only 700 pages, so you can download it and read it. Don't print it, please. And that one of the outcomes of that report is that personal data and information available for machine learning is a very important asset for every country that touches national security. So, I'm throwing this idea of we need to think about this. I mean, how do you grant access to a database? And that will be, I guess, my overview about Argentina. So,
Thank you very much. Thank you. That was insightful. Okay, now, second speaker, we will proceed with Nelson, who is joining us remotely. So Nelson de Molina Angarita is Associate Professor and Director of the Graduate School at the University de los Andes in Bogotá, Colombia. He's also former Commissioner of the Colombian Data Protection Authority, and he was in office from October 2018 to March 2022. So Nelson will be discussing in Spanish. Unfortunately, there is no translation provided, but Pablo will kindly keep notes and then provide us with a brief summary of Nelson's intervention so that we can follow for those who do not speak. So, Nelson, thank you for being here and the floor is yours.
Hola, buenas tardes. ¿Me escuchan bien? Ok. Bueno, gracias por la invitación. Muchas felicitaciones por el evento. Gracias, Caterina, por su paciencia y Pablo por toda su ayuda para traducir mis ideas de español a inglés. Voy a ser muy breve. Realmente este es un tema que podemos pensarlo de manera macro en el mundo, pero al final se reduce en los términos micro en lo que está sucediendo en la regulación de cada país. Ustedes saben, pues ya básicamente tenemos alrededor de 142 leyes generales de protección de datos y usualmente ellas tienen algunos ámbitos de aplicación, excepciones o regímenes especiales. Y sobre este tema de investigación, pues en algunas se menciona, en otros ni siquiera se hace una mención a estos aspectos. Yo voy acá a compartirles un poco sobre lo que sería la visión desde la Red Iberoamericana de Protección de Datos, partiendo de la base, insisto, que habría que mirar cada país qué dice en su ámbito de aplicación, en sus excepciones, como lo comentó Pablo para el caso de Argentina. Entonces, yo quisiera destacar lo siguiente muy rápidamente. Las normas de protección de datos son neutrales tecnológicamente, de manera que eso es algo que viene de siempre cuando se empezaron a redactar. No se pensaron para hacer tratamiento de datos únicamente con ciertas tecnologías, sino con las tecnologías que habían en ese momento, las del pasado y las que van surgiendo. De manera que, si uno mira, pues esto también aplicaría a la neurociencia, neuroderechos y muchas otras cosas. Y eso es algo muy importante de no perderlo de vista, la neutralidad tecnológica de la regulación. Ahora, siempre habrá que hacer ejercicios de si es necesario hacer ajustes o no a esas regulaciones. Bueno, eso obviamente uno no puede partir que la regulación actual es perfecta, pero sí destacar esto, ¿no? Porque también habría que mirar si es necesario entonces estar regulando tecnología por tecnología para dar espacios a algunas cosas, o si con la regulación que tenemos se pueden hacer esas cosas sin necesidad de modificar la regulación. En Iberoamérica está la Red Iberoamericana de Protección de Datos. Ustedes ven en pantalla el documento más importante de la red. Este se aprobó en 2017 en Chile. Son los estándares iberoamericanos para la protección de datos. Ahí está en español, portugués, francés, inglés. Los invito a que lo consulten, porque este documento, aunque no es jurídicamente vinculante, pues ha sido un referente, como muchos otros que se han expedido en el mundo, y lo que se quiere con esto, dentro de los objetivos, es, por un lado, enviar mensajes a los reguladores en diferentes países en la región para tener presente estas ideas, estos lineamientos, para que sean incorporados en la regulación de cada país. Sobre investigación, estos estándares no dicen nada, pero hay cosas muy importantes que Pablo ya mencionó y que son útiles tenerlo presente. El primer tema es el ámbito de aplicación de estos estándares, pues que deja por fuera todo tratamiento de datos en investigación que se haga con datos anonimizados. Entonces hay que mirar si eso ya es suficiente o no. Es decir, quien esté haciendo un estudio en investigación, pues acudir al tema de la anonimización y un poco ya se desentendería, no se tendría que preocupar por la regulación de datos. Ese es un punto también muy importante. Otro que está en estos estándares es la ponderación de derechos. Me parece que también es clave. porque la protección de datos no es un derecho absoluto, pero ningún derecho es absoluto. Entonces, siempre viene acá un ejercicio muy importante en las excepciones que hagan o los regímenes especiales que hagan los reguladores de cada país para ponderar intereses válidos para la sociedad, como lo son seguramente la innovación tecnológica, pero también ponderar los derechos individuales de cada persona. Eso me parece importante, pero ahí en los estándares se deja ese mensaje muy importante que ustedes ya muy bien conocen, pero me parece importante rescatarlo de nuevo. Y otro tema, algo que a veces uno ve sobre estudios o uso de datos para investigaciones, a veces la preocupación por el consentimiento, pero a veces la preocupación también por la finalidad. Bueno, en este tema, por lo menos, estos estándares, para efectos de la finalidad, pues dejó abierto e incluye el tema de que cuando haya tratamiento ulteriores de datos, se pueden utilizar para fines de investigación científica e histórica. Entonces ya está dando por lo menos expresamente un paso hacia estos temas. Ahora, recalco que esto no es nuevo, viene de hace tiempo, pero es el documento actual que hay que hacer referencia. Y finalmente, me parece también importante mencionar cómo la Red Americana de Datos, desde 2019, creo que ha sido uno de los documentos pioneros en el mundo de inteligencia artificial y datos. Digo específicamente en ese tema, porque pues quizás de inteligencia artificial ha habido muchos, pero inteligencia artificial y datos, este puede ser quizás uno de los primeros. Y se despidieron dos documentos, unos principios o recomendaciones generales, ahí están las versiones en español, en inglés, y otras unas orientaciones específicas ya para implementar en la práctica el tema del respeto a los principios en proyectos de inteligencia artificial. Eso me parece también importante no perderlo de vista. Estos documentos pues los hizo la red con la colaboración de todos los miembros de la red. La red actualmente son 35, digamos, organizaciones, ahí están 17 autoridades, y están un poco pues dando su punto de vista sobre el tema. Me parece clave tenerlo presente. En estos estándares no se hace mención tampoco al tema de investigación científica como tal, sino es en general para tenerlo presente, pero me parece clave que en todo caso se tengan presentes esas recomendaciones que son muy comunes, que ya son muy conocidas, pero que tienen un enfoque netamente preventivo y que detrás de todo esto siempre está la gran pregunta, no sé si sea la más importante, pero si todo lo tecnológicamente posible es socialmente deseable, y los límites que hay que ponerle a esto, y más que límites regulatorios, son los límites éticos, que me parece también importante no perderlos de vista. Si ustedes revisan estos estándares, y voy a dejar de hablar porque ya he hablado mucho, pues tienen un enfoque preventivo. Y ahí está, entre otras, algo que mencionó Pablo, las herramientas de anonimización, asegurar la calidad de los datos, porque si los datos de entrada no son de calidad, seguramente los datos de salida van a ser problemáticos, lo que se haga con ello. Y el tema ético me parece que es algo muy, muy, muy importante. Bueno, yo por ahora dejo de hablar para escuchar a los demás y más tarde quizás conversar si hay preguntas. Muchas gracias.
Muchas gracias, Nelson. Do you feel confident in? Okay, thank you so much.
So I'm going to summarize Nelson's lecture. He said that there are two visions on this. One is a macro vision, which is what's happening in the world, and then a micro vision in each country, that you need to see what's happening in each country, specifically in the letter of the law of each country. And there are 142 laws about data protection in the world. Only some of them mention AI, or they have an AI provision like algorithm decision making. And then he told us about the view of the Ibero-American network of data protection. He said that the data protection laws are neutral. He asked if we need to regulate each technology separately with a new technology, or we can use existing data protection laws to cover what's happening with a new technology. Then he told us about 3 documents of the Ibero-American network of data protection, which comprise 17 authorities of Latin America. The first one is the Estándares Iberoamericanos de Protección de Datos, which is soft law. It was made in 2017, and it's basically to catch up with GDPR. It's a summary of all data protection laws of Latin America, compiling one document, which again is not an approved law, but is soft law. But because it was approved by all the data protection authorities, need to be taken into account, I guess. And he mentioned three things there in Article 17. First, anonymized data, which is out of scope of data protection law. So if you have data which is anonymized and is not personal, that's an issue for research because you don't have the problem with data protection. Second, the balance of rights. He said that we need exceptions, balanced rights, and we need to take into account this with the research exception because it's a balance between, for example, innovation and a new AI project and data protection. And third, he mentioned Article 17.3 of the standards, which mentions scientific investigations purposes for statistical purposes as an exception to the purpose limitation principle. And then the other two documents were drafted in 2018 by the Radio Iberoamericana. One is a general guide of AI and data protection, which is pioneer in the world because maybe it was the first on addressing the issues of data protection and AI at a regional level. And the second one is a specific guidance on how to implement data protection principles into AI projects. This last one does not mention the scientific exception for research. That's it.
Thank you very much. Thank you, Nelson, once again, and Pablo for the effort. And now we proceed to the third speaker, Lucas Borges. I hope, yes. So Lucas is an advisor for the Board of Directors of the Brazilian Data Protection Authority, the ANPD. He holds a PhD degree in Constitutional Law from the University of Brasilia and a master's degree in Philosophy of Law from the Federal University of Santa Catarina. He's a civil servant since 2007 with experience in different public organizations such as the National Telecommunications Regulator, Anatel, the Ministry of Communications, and the Ministry of Culture. So the floor is yours to walk us through what Brazil has to say about the topic. Do you prefer to come here because you have a presentation?
I think Pablo will help me here. Yeah, you can next one, please. Yeah. So thanks for having me. I will mention here two important legal concepts from LGPD, and then I'll mention two challenges. But first, I'd like to bring some context for this discussion. The first is in that slide. What I want to bring here, these three principles that I took from UNESCO recommendation on open science and on the ethics of artificial intelligence, is two ideas. The first is that to remember the reason why exists an exception for research in data protection law. That's the idea of collective benefit. As a global public good, open science should be, I'm reading here, belong to humanity in common and benefit humanity as a whole. To this end, scientific knowledge should be openly available and its benefits universally shared. So I think that's the main reason why data protection law treats scientific research differently. The law is protecting and encourages innovation and the collective benefit it creates. Another consequence here is that not every kind of research should benefit from this exception. The second idea that is expressed by the second and third principles is what research exemption doesn't mean. I'm not going to read these two principles, but the idea that I want to bring here is that these exceptions cannot be understood as an open door for deregulation or to actions that imply a violation of fundamental rights. We know that AI development needs a vast amount of data. Nevertheless, the processing of this data must be carried out under ethical standards and the principles established in data protection law. So this is a broad context, and should you please, yes, next. I will go next to LGPD. Just to highlight that this is a new law, right? And so there is many many doubts on the concepts of LGPD. So broad legal uncertainty regarding basic concepts and rules, specifically in the regarding data processing for research purpose. There is a lot of uncertainty about basic concepts and the scope of some of the rules established in the law. Taking this into account, we have just published a paper on this topic, and the paper analyzes the main legal concept that I will mention next, presents some recommendations, and establish some standards that may help controllers deal with practical issues. We have received many contributions, and the next steps are to read and evaluate contributions, and as soon as possible, publish a new version accompanied by practical recommendations. So now I will mention the two legal concepts that are very important to this discussion. The first one is academic purpose. LGPD does not apply to the processing of personal data carried out exclusively for academic purposes. The main question here is about the extension and the range of this legal exception. So what we are addressing, what we are exposing in our paper is that academic purposes means that the processing is strictly associated with academic freedom. I mean, with freedom of expression. This means that, in general, LGPD should not be used as a means of censorship or as a barrier to innovation and scientific development. The point is that to foster the collective benefit generated by scientific research, legal restrictions are reduced. In general, this legal exception applies benefits teachers, students, and researchers, usually in academic environments, like schools, universities, and research entities. And if the processing serves different purposes, for example, commercial ones, the controller cannot benefit from this legal exception. The second concept here, main concept, is research entity. We don't have an official translation of LGPD, so some people use the expression research body or research institution. I choose here a research entity. So what does this mean? The concept is a research entity is a non-profit legal entity or a public institution dedicated to develop scientific, technological, or statistical research. In that case, there is a specific lawful basis carrying out studies by research entities that is also available for sensitive data. So in that case, if the controller is a research entity, it's not necessary to rely, for example, on the legitimate interest basis to process data for scientific research, as it would happen in this GDPR. Another important point is that as they are not research entities, companies cannot rely on this legal basis. In practice, companies will face a greater legal burden in comparison with research entities. So next, this is now I mentioned two important challenges. I don't have good answers for this challenge. I will just here bring some questions. And the first one is private sector research and public-private partnerships. As I mentioned, the LGPD framework makes it easy for nonprofits and for public institutions, but it's not clear about what happens with private sector research. What is the legal framework that should apply in this context? As I mentioned in the first slides, we have also the question about collective benefits. That should be a guideline in the interpretation of this point. And in practice, another question, another issue is that it's not easy to draw the line between a research that is public and private research, because in practice, as we know, universities, companies, they are acting in public-private partnerships for example, when a company funds research in a university. So it's not easy to draw the line here. As we were talking earlier here, we have this little box, these concepts, legal concepts, but in practice, the real life doesn't fit in these concepts in an easy manner. So this is a challenge, I think. And as a general answer here would be that we need a balanced approach that fosters data-driven innovation and avoid disproportional restrictions, regardless of if the research is on the private sector or on the public sector. But obviously, we need to treat differently this kind of situation, but having this in mind that we need a balanced approach and that it's not easy to draw the line between one and another situation. And to end up here, data access and sharing. We are, in our paper, we are dealing specifically with public sector. I think Marcela will talk a little bit about this. So the main question here is the resistance to greater transparency on questionable grounds of data protection. We have a great culture of secrecy in Brazil, and as I mentioned before, legal uncertainty regarding basic concepts of LGPD. So authorities doesn't feel confident, and they don't know exactly if what they are doing when sharing data, if it's in accordance with law. So they usually, and it has been very common to deny access to research, deny access to data to researchers. And another practical issue here is that some public institutions have interpreted LGPD in the sense that only anonymized data can be shared with researchers. That's not true, because LGPD doesn't mention this. I will not talk about this anymore because Marcela will speak about that. And the last question here is a kind of bureaucratic and red tape question. It may sound awkward, but this is a real question. And sometimes we are discussing the big picture, but at the point we are in Brazil, we need to answer this kind of question, how to identify and how to prove that someone is a researcher in the research entity. In practice, the point is some institutions, public institutions, don't know exactly how to answer this question, so they just deny access to data because they know exactly what document, what statement they need to ask for the researcher and the research entity. So that's what I have here. Thank you very much.
Thank you very much. And I would like to make just a small comment that the questions that you raise that are not solved by the LGBT, I have to admit that while the GDPR has a long history, like data protection law in Europe has a long history, I still find similar questions being raised. So these are not really clear, not even under the GDPR. Thank you very much. So now we will go to Marcela. Marcela Matiuzzo. She's a partner at VMCA in the practices of data protection and competition. Marcela is also a PhD candidate at the University of Sao Paulo and a professor from the MBA on Artificial Intelligence and Big Data from the Institute of Mathematical and Computer Sciences at USP. She's a former advisor and chief to staff to the Office of the President of the Brazilian Antitrust Authority. So, thank you very much.
No, thank you and thanks everyone for being here for this discussion today. As Lucas already mentioned, we are in a very different scenario than that of Pablo. So instead of having a law that is 22 years old, we have a law that is very, very new and an authority that is even, it's kind of a baby authority. It's in its early stages of development. So though we have a lot of regulation to be interpreted, we still don't have final interpretation on the terms that are on the law. And in terms of the research exemption, I think Lucas already very clearly stated that we have a couple of questions that need answering, right? So One is, what is a research institution or entity, or whatever English translation you want to use for that. And we have some orientation in the law itself, but we still have a lot of room for discussion, when basically what the law says is you have to have the purpose of research in your bylaws. Great, but should that, is that enough? How do we analyze it? Then will the DPA ask for your bylaws? And if you do that, anything you do can be considered research. Doesn't really make sense. So that's complicated in itself. And then we have also the individuals, right? So who is a researcher? Even if that individual person is part of an institution that you can rightfully claim to be a research body or a research entity, how do we make that connection, right? So is what that specific person is doing really research? How does it fall within the research exemption? So that is all on the one side of what exactly a researcher or research institution should be in order to even be considered for the application of the research exemption in the LGPD. And on the other side, and I think Lucas very clearly put this, but it's relevant to point out because a lot of question has been raised about this point, is if I'm not a researcher or a research body, can I still carry out research in Brazil that uses personal data? Yes. It's kind of obvious, but yes, you can. The only thing you cannot do, according to the LGPD, is you cannot use the research exemption in order to do that. So that raises a whole lot of other questions, which we have yet to fully discuss, which is, fine, then if I'm a private institution carrying out research, what is the best legal basis for me to use? How should I analyze the process of research? How do I document it to make it data protection bulletproof? I think that's a whole set of other discussions that we have yet to have. And as Lucas also mentioned, there's the interconnection of those two things, right? So I'm a private institution carrying out research on behalf of a public body. Am I able to use this exemption extensively? Yes or no? If you look at the letter of the law, in theory, you cannot. But does it make sense to expand this understanding in specific situations? If yes, which situations are those? So again, we don't really have final answers on any of these questions, but they have all been raised, and I think they will be answered throughout time as we discuss this topic further. But the other topic that I wanted to touch upon was that connection between research, private institutions, and the very complicated question that has been raised in Brazil regarding access to information generally, right? So as the Brazilians in the room will probably know, we have a specific law, LAI, that governs access to information from the public sector. And we've had one specific case, which is what we're now calling, I don't know if this is everyone calls it that, but I do, so I'll just use the name that I use, which is the case of INEP, which is a public institution, an institute of research focused on education in Brazil, that basically decided that it would stop sharing microdata from relevant databases, educational databases in Brazil, and entirely based this decision on stopping to share such microdata on the fact that it was unlawful because of the data protection legislation, because of the LGPD. I really am not exaggerating when I say that this caused within the third sector educational institutions chaos and despair on the part of those institutions, which was we are unable to carry out research if we do not, I mean, at least to some extent, if we do not have access to such information. Just to give you a more concrete example of what I mean by that is, like, some of the information that was not anymore disclosed was information regarding ethnicity of the students. And as you can imagine, that is particularly relevant if you want to make a connection in between, for example, ethnical origin of a given group of students and their, educational level, how much they develop, if there is a connection to be made there, etc. So that caused really chaos and despair on the part of those institutions. Thankfully, the DPA later came on and said, okay, so you cannot really say that the LGPD is what is preventing you from granting access to that data. Because, as Luca said, there is nothing in the law that says that the only way in which you can share data for research purposes, so with researchers, is by anonymizing the full extent of the data. So if you cannot anonymize a certain database, you cannot share it. So nothing in the law says that. What the law does say is that if you're carrying out research and you're using that logic, that legal basis, in as much as you can anonymize, do. But it doesn't say that you have to anonymize everything unless, otherwise you cannot carry out any processing of data. So this clarification from the Data Protection Authority was very relevant to, put clearly on the table that first, anonymization is not a requirement. It was already said in the law, but this was an interpretation that was becoming frequent. It's not a requirement for you to share data for research purposes, especially if you're a public body, right? A public authority. You do not have to necessarily anonymize everything. And also that you cannot use the data protection legislation to hide behind and say that you're not going to share data that could be of public interest more broadly, not just for research, because that's just not what the law was created for. It's those systems of access to information and data protection are not, by definition, incompatible. They have to be compatible. So I think this case of INEP is interesting for us because first it's cleared some ground on some basic rules that were not fully perhaps comprehended by everyone. But it also did not answer all of the questions that I raised previously. And I think we're at the moment, and I'll reemphasize Luca's point. The Data Protection Authority today has a working paper on this discussion that is open to comments. So everyone here can just, submit comments on that paper. And I think that my feeling is that we need that at this point because it's very important, for example, to hear from researchers themselves what would be helpful, especially in their daily use of data, right? So what are the issues that come about? And of course, in different areas, we face different issues. So I'm pretty sure that the issues that I face in law, even when I want to carry out interviews, are completely different from the issues in other areas. So that might also be relevant as well for us to, grasp a little bit more of this discussion and try to go a little bit further. But just to conclude, I think we're very far from arriving at a definite point in which we have answers to everything. But the discussion is very much alive. And, hopefully our panel here can help advance it. So thank you again, and let's hear more in the questions.
Thank you very much. It's interesting to see that although the LGPD is quite a new law, that the questions that you raise and the issues that you tackle in the public debate are so aligned with what is interesting and that needs a solution. So thank you very much. And now, last but not least, my colleague Lee Matheson. So Lee is a senior counsel for global privacy with the Future of Privacy Forum Global Privacy Team. Before coming to the FPF, Lee was a member of the Privacy and Cybersecurity Group at Crowell and Moring, LLP, and a Western Research Fellow with the IPP. And Lee will give us, will walk us through the EU landscape and the GDPR and how it deals with the topic.
Hello. Are we? All right, am I like strangling anyone with the cord here? No, good, all right. So as an initial matter, I maybe have some disappointing news, at least based on the EU experience, for my panelists discussing the new experience of the LGPD with regard to these questions, and that's that they're not settled in Europe either. And the GDPR has also been concerned with the question, I guess the related questions of how to manage scientific research as a distinct type of data processing activity, along with the development of AI and the broader applicability of data protection and data privacy. I think as an initial matter, I should mention that under the GDPR, just like every other kind of personal data processing, processing for research activity is subject to the full scope of the law initially. So most critically in this context, that means that all research processing needs to comply with the Article 5 principles, those including lawfulness, fairness, transparency, data minimization, storage limitation, purpose limitation. I could go through all of them, they're fun. And then also have a lawful basis for that processing, the 6 of which are laid out in Article 6. The 2 that tend to be the most relevant for the purposes of scientific research, although they are not exclusively relevant, are consent as a lawful basis for processing, and most notably processing for the legitimate interest of the data controller or a third party, Article 6F. I should note that unlike the LGPD, processing for the purposes of conducting academic scientific research is not a specifically detailed separate lawful basis under the GDPR. So usually, if research is a specified purpose, either an initial purpose or a subsequent additional purpose for personal data that has been collected or processed, it is not the lawful basis of that processing. That is usually the case. It's usually the case that that would be legitimate interest or consent. So that brings me to another article of the GDPR that specifically deals with scientific research, and that's Article 89. And Article 89 basically functions in 2 ways. One, it deals with a set of so there's sort of a fundamental question here for oh my goodness, I'm sorry, my in an example of spectacularly poor timing, my outline has decided to crash right now. Here we go. So basically, the GDPR's regime for the processing of scientific data and the conducting of scientific research in the context of the broader data protection regime can be summarized as specific derogations from particular controller obligations, and then a specific provision that requires particular standards of processing for scientific research. Wow. I guess I'll talk louder. But the underlying goal of what Article 89 does, and I'll get into this in a moment, is to create a fair balance between the individual rights and the underlying principles guaranteed by the GDPR and the potential benefits of processing for research purposes. And one cannot simply claim that the purpose of a processing activity is research and then toddle off with the derogations to the individual rights that are permitted under that article. So Article 89 basically says that if the processing is for scientific and historical research purposes, it must be subject to appropriate safeguards to protect the rights and freedoms of the data subject. That article notes that the specific focus of those technical and organizational safeguards should be to enable data minimization or anonymization or pseudonymization to the extent that it is possible. And if that is the case, then union and member state law may permit derogations from some of the individual data subject rights outlined in Chapter 3. Now, those rights are the right to access personal information, the right to request the deletion of personal information, the right to rectify personal information, and particularly notable in the research context, the right to object to the processing of data if it is under the legitimate interest purpose authorized by the Article 6F lawful basis. Now, another component to this question is also what counts as scientific research, under what sort of processing activity is authorized as scientific research in order to take advantage of the flexibility offered by Article 89, and then the question of whether or not scientific research is the original purpose for the processing of data, or it functions as an additional purpose to processing data that was originally collected for some other reason. So I've gone through the short list of the exceptions that Article 89 basically allows member states to authorize as derogations to the individual rights. And I should also mention that the question of what a scientific purpose is covered in several of the recitals, as well as a draft EDPS opinion, and even goes back to the Treaty on Function of the European Union, Article 179. Essentially, the idea is that scientific purposes should be interpreted broadly. There is a general consensus that scientific purposes are not limited to scientific research conducted in the academic or university context, and can also involve applied research or privately funded research. It basically both, if you look at Recital 156 and Recital 159, the suggestion is that while the technical and organizational members in place necessary to that should assist with both guaranteeing the necessity and proportionality of processing, and that research should consider potentially other applicable regulatory structures, such as those surrounding clinical trials. The broader purpose should drill down to the underlying treaties, which is basically achieving a broader European research area in which research, scientific knowledge, and technology circulate freely. I think that brings us to the major intersection of this question and the functioning of this exemption with the area of AI. And that is because so much AI research is conducted in the private sector. Where does a for-profit private entity conducting research to improve its algorithms or to improve an AI-driven product or service rise to the underlying goal discussed in Recital 156, 159, and ultimately the TFEU, Article 179. The text certainly suggests, in fact, the text guarantees that a for-profit entity can benefit from these exceptions, but not that it always will. One of my former IAPP colleagues wrote an article several years ago suggesting that private research for technological development, for example, which is specifically mentioned in Recital 156, likely can qualify as research under the exemption, but there is probably an underlying necessity for transparency and the ability for other researchers to examine and perhaps challenge the conclusions of research activity. How this would apply, I think, in the context of research done to improve the operation of an AI service or an algorithm is an open question for the future, because that's a lot tougher to do than traditional large R academic research activities. So I think it will be interesting to see where the data protection authorities in Europe come out on this subject. To my knowledge, while there has been significant enforcement activity about AI and machine learning, in fact detailed by my colleagues in one of their recent reports, most of it has centered around the enforcement of Article 22, or some of the more basic GDPR rights, the individual data subject rights in Chapter 3, or even the underlying principles in Articles 5 and 6. and relatively little enforcement activity has occurred on the basis of an enforcement authority challenging a private party's assertion of the research exception guaranteed in Article 89. I think that it's possible that going forward, if a private sector entity looks to take advantage of a derogation from one of the individual rights, asserts that its activity, whatever it is research being conducted pursuant to Article 89, and a regulator disagrees, we'll see authoritative decision-making on that topic. And I think that that's probably the next place that the EU regulatory apparatus is going to go. So I hope that that was at least somewhat coherent in terms of laying out the EU's approach to this issue and where I see it intersecting, particularly with the development of AI and research being done on artificial intelligence. Thanks.
It is clear that the questions raised are way more than the answers that we have at the moment. So thank you very much, all of you, for these very insightful points you made. I would like, so we still have, it's like 3:15, so we have 18 minutes for discussion, questions, comments, whatever you feel like. So I would like to open the floor to you. If there are questions, we would be happy to answer them. So, yes. If you could also state like your affiliation and your name, that would be great.
Hello, Ace. And you thought outline was the only problem you had this afternoon. Lucas Anjos, I work at the Brazilian Data Protection Authority. Very interesting notes. I think you touched on several issues that are on the table right now in Brazil, so I think it fosters a lot of discussions for us. And one of the issues that struck me was the fact that you mentioned data access as an exemption to copyrights, for example, or even trade secrets when you're talking about probably mining data, databases, and things like that. So that was one of the discussions we had in the Brazilian Senate when it came to the artificial intelligence bill that is being discussed right now. One of the proposals was to have a copyright exception for databases in order for research to be conducted, and even for anti or competitive purposes when it comes to different actors in a given market. Do you think we should propose those sort of regulations or insertions of regulations when it comes to copyright laws, such as the case in Brazil? Or should we, as a legislative approach, mention that within the realm of data protection laws, such as the LGPD? Because we already talk a lot about safeguarding trade secrets in the Brazilian law. We mentioned it several times. So in a way, we're also regulating intellectual property in the data protection law, but within a protective scope of private actors. So what do you think it's a good approach for assuring, I don't know, data access or thinking about that in the future?
Thank you. This is clearly for you, I guess.
I'm sorry, but I really don't know the answer. I was setting the stage, and to have a huge view of things, I was saying that not only data protection may be an obstacle, but also intellectual property. And because data and databases are protected by a three tier of copyright, sui generis right in the European Union and Mexico, and trade secret, well, that's an obstacle, because if I said if artificial intelligence programs are going to be a public good, and I want to have access to that, and I want to facilitate access, this is the typical academic speech that you will hear. You will need some exception for that, as you have, for example, in medicine, exception for medicine at the OMC, but then, you know, too complicated to discuss this. It's out of the scope of a conference on privacy, and I haven't researched it too much to tell you we have to go that way or that way or that way. I was feeling that it's another thing to take into account when we discuss privacy, not only privacy, because maybe you solve the privacy issue, and then, hey, wait a minute, I'm the owner of this database. I'm not letting you access, because not on privacy or third-party protection, but on my copyright rights or derecho de autor or even trade secrets. So it's sorry, I'm not answering because I don't have the answer. Sorry.
Okay, thank you. There is a question there. Sure.
Hi, my name is Nicolas Zingales. I'm from FGV. Thank you for a very interesting discussion. I noticed that we are recognizing that there are some blurred line in terms of how far, what's the scope of the research exemption. And I wanted to provoke you with a couple of specific scenarios. So one is, what happens when the researcher has used a lot of data for the research exemption, and then this is used to develop a product? Is this, when it's commercialized, does it take you out of the research exemption? And what happens also if you are funded by a private corporation for doing that research, for example? Would that also need to be out of the scope? And another scenario that I think it's interesting to consider here is also an obligation that is going to be imposed by the Digital Services Act in Europe, and also here potentially by the Brazilian fake news bill, which is that researchers will need to have access to the platform data. So the platform data has been collected for other purposes, and then the companies will need to share it with the researchers to understand the harms that these platforms can cause to society. So would this fall in the research exception? Also not only the researchers' use of that data, but also the sharing itself. Would it be in this exemption, or would it be rather compliance with legal obligation, or what is the legal basis that you envisage using there in that context? And also, if you can say until when is the consultation for the document, because it's very useful.
Okay, so I understand that this question is about, like, anyone can answer, right? You don't specifically. Yes. I see that you really want to answer.
Yes, so at least to the first part of your question regarding whether essentially, basically, if data collected for research purposes is then used or applied or processed in a commercial context, I can tell you that the GDPR, handles the idea of processing data for an additional purpose aside from the originally specified purpose, with the test of, whether or not the additional purpose is compatible with the original purpose. Now, there is a particular interaction with research in the research context. If you look at Article 5.1b, there's a presumption of compatibility if the subsequent process, the subsequent purpose is research, and it meets the strictures of Article 89.1 with the appropriate technical and organizational measures. That doesn't go the other way around, as I understand it. So if your original purpose is research, and then you have a subsequent purpose that wasn't originally specified to the data subjects, you don't get any sort of equivalent assumption of compatibility, and you'd have to undertake the full compatibility analysis of the GDPR. So at least on that point, I think that there's not a lot of question how the European structure would handle it. I'll leave it to my colleagues to answer the rest of your question, which is also interesting.
So maybe, Lucas, you want to talk about the consultation?
The term is over. It was on June, but if you want to send us, you can just email me, and then we can talk, and you can send me, because we are right now reading and evaluating. So there is still some time, and then we will be grateful if you have any comments or suggestions. And answering your question. One of your questions. The point is LGPD chooses to a legal personality line. Yes, so research entity is a formal concept, a legal, if you are non-profit or if you are a public institution. So this is the line that we have on the law. And this is an option, and there are sort of problems here because, as I mentioned, and as you mentioned too, in practice, it's not easy, it's not clear because in real world, what we have is public-private partnership. So you develop a product for a company, you have fund for a company. Now, this is real world, yes, but that's the option that is in law. But what can be said here is that it's not sure that it's not illegal. Yes, it's not illegal. You can develop a product. You can use data for that. You just have to comply with the law to choose the correct legal basis and so the other safeguards and so on. That's what we have for today. And it's kind of funny because the law creates this legal exception, but there are so many things that don't fit in the legal exception, and we need to, lawyers and ANPG and law scholars need to think about where to fit this reality. But the only sure we have here, the only point we can defend here, argue here is that it's not forbidden. You can do this, you just need to look at the law and find the correct path to this data processing.
Yeah, if I may add just a couple of thoughts. I think your question, Inclui, when it comes to like, I am a research entity, in the exact terms that it's, the LGPD states, but I do get private funding for whatever it is, for a specific research project, for example. I think the answer on whether or not you would be able to use the research exemption would depend on the specificities of your research project. So, I mean, it's possible that, someone funds research and the only purpose of that is for that research institution to carry out that research and, I don't know, publish a paper maybe. I don't think that would fall outside the scope of the exemption. In my view, it falls within. But then is what Lucas said, right? So what if I start using that for some other purpose? Or more specifically, what if I give access to the database that I collected for the research purpose to someone that will use it for another purpose that is not research? Then I think, again, we probably would not be able to use the research exemption necessarily, and we would have to resort to another legal basis. But I don't think the mere fact that you have a partnership with a private institution automatically disqualifies you from using the exemption. I'd say that maybe you would have to, look at how the research is being carried out for that specific purpose. But I mean, that's just me. Maybe I'm wrong. I don't know.
And that's because there are many cases where you have a university, a public institution that is funded by a private party to perform research by researchers employed in the public institution. So, I mean, these are a bit of gray areas, right? Exactly. Funded by a private party that will be the product of the university, you mean? Yeah. Because I guess if the product of the university is going to is for the private party, then it's clear. Yeah, for profit. Made by the university itself. Right? Yeah. Put in the market by a university. Yeah.
I suspect this is a major reason that the GDPR does not make this distinction explicitly on the basis of the type of party conducting the research, but rather what kind of activity it is. Yeah. That's all.
No, that's. I would say that this is quite accurate because it's like, what is the intention? What is there a public good? Is there a public interest instead of who funds what? But this is really something to be solved by an opinion or guidelines that we are waiting for. So, is there any other question? I don't see any hands. You, yeah,
Not
sure.
I can follow up on the second that was not answered. But it's about basically, can this also cover some entity sharing data, perhaps not when it's legally obliged to do it, but sharing data with researchers? So, okay, this applies to researchers, but what about the entity itself?
I'm answering as a lawyer here. So when I get that question, which I get a lot, I usually would say like, okay, there's some level of risk for you to use the research exemption, also because first, you do not control what the researcher or research institution is going to do. And if you want to meddle into that by using the research exemption, you're attracting a lot of liability for yourself, right? And maybe you don't want that. But I do not think that it's entirely unfeasible for that to be an interpretation. I think it could be done. I honestly think that on the side of whoever is sharing the data, it would be more a question on the liability side of, you know, do I want to take that risk for myself? Because then I you know, how the research is being carried out and the whole process of the research kind of to some extent becomes my responsibility perhaps, or I have some liability related to that, and you know.
I think there in that specific example, you can actually see one of the primary use cases for the secondary, the additional secondary processing purpose compatibility assumption in the GDPR, because there the original controller then would mostly be focused on ensuring with great care that the requirements set out in Article 89 for technical and organizational measures that preserve the rights of the data subjects whose data is being, you know, processed additionally for this research purpose, even if that includes, you know, a third-party researcher, that those requirements are met. And then there, the additional processing activity, you know, likely, I think, would probably fall under that use case. I'm not familiar enough, I guess, with the LGPD to know, you know, if there's a sort of equivalent purpose specification mechanism for that activity that you're describing. But
no, there's only a general principle on purpose compatibility, but it's not specifically to research. Yes.
Thank you. Any other question from the audience, or opinion or a comment? That would be also nice. No. No, I don't see anything. So we still have 1 minute. And in the last minute, I would like to ask a question to Nelson. Hi, Nelson. Okay, so I do have a question for you. So you discussed the Ibero-American network. We do know that Latin America does not have a common approach when it comes to data protection laws and, of course, artificial intelligence. So there are multiple gears. And the Ibero-American network has published the guidelines that you referred to. So I was wondering, what do you think about, do you think that this network is capable of setting a common tone when it comes to these issues, to the different, disregarding the differences among the Latin America countries? Like, how do you see that aligning? Thank you.
Gracias, Caterina. Caterine. Bueno, yo plantearé lo siguiente. Primero, la red americana, quienes la integran son autoridades de datos, no son los reguladores de tema de materia de datos. Pero la red un poco se ha sumado a otras organizaciones que han tratado de que haya una armonización internacional, así como está pues, la Unión Europea, la ONU y la OEA, etcétera, etcétera. Lo que ha tratado la red es buscar que haya cierta armonización en la región, pero no es fácil, como no se ha logrado en el mundo. Si ustedes ven, el mundo todavía no tiene un tratado internacional en materia de protección de datos. La visión imperante, por lo menos en materia de documentos internacionales internacionales vinculantes es la europea, convenio 108, convenio 108 Plus, pero no se ha logrado esa armonización porque hay muchos enfoques. Antes hablaba uno del enfoque norteamericano y europeo, hoy hay que mirar otros enfoques como lo que está pasando en África y Asia. Entonces creo que va a ser difícil lograr sobre esto unificación, pero hay que seguir trabajando en armonización en estos temas. Y las autoridades y la red, por ejemplo, pues también algo que han venido haciendo es, en materia de investigación, es acudir a mecanismos como los sandbox también, como otra forma de regular, pero no improvisando, sino regular investigando para, digamos, hacia futuro, generar una regulación más comprobada que realmente sea útil para todos.
So I will try to make a summary of Nelson's comments. He said
Gracias,
that,
Pablo.
De nada. He said that the Radio Iberoamericana is composed of regulators, of DPAs, but it's not a regulatory body itself, so they don't create applicable laws directly. But the Radio Iberoamericana has joined other organizations globally to try to harmonize. But if you see at the world, the data protection is not harmonized. There's no international treaty on data privacy or data protection. And also, there are different views. It used to be only the US and Europe, and now you have, apart from Latin America, Africa and Asia. So but there are a lot of things that are similar, but things that are different. And also they have created sandboxes. They have proposed sandbox in Colombia. I think there's one case of sandbox for data protection, which is a good alternative to try things.
Thank you very much. So I guess this will be the end. I would like to thank you, Lucas, Marcela, Pablo, Lee, and Nelson for joining this panel. Thank you very much for participating, asking questions, and being here. And yeah, see you around. Enjoy the rest of the conference. Thank you very much.